The topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio, its employees, or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good morning. No, this is not morning. It's afternoon. Too many shows in one day. Hey, welcome to Ask the Experts, where we bring you educational information in health, legal, financial, and home improvement. This is the first Thursday of the month, and that means community association law. We have the K. Bender Rimbaum law firm, and we have board certified lawyer Robert K. If you'd like to call in today, our phone number here is 561-623-9429. Or if you're watching us on TV today, you can go to the chat line right on the right-hand side of the page. Write your question in. Last Thursday, we had a ton of people writing in on the chat line. So let's welcome our longtime guest, Mr. Robert K., attorney Robert K. Hey, Robert.
Hello, Steve. Hello, everybody.
Well, we're glad to see you. Last time we saw you, you had a patch on your eye. You just got through with surgery. You still can't see, but no patch though, right?
Well, I'm seeing a little bit, so it's coming along.
Okay. So you know what? We are getting new viewers and listeners now by the day. So tell people about K. Bender Rimbaum.
Well, K. Bender Rimbaum is a full-service law firm that focuses on community association representation, condominiums, homeowner association, cooperatives primarily, working for our clients in our offices in Pompano Beach, Palm Beach Gardens, Tampa, and Orlando currently. I've been providing these services continuously for over 30 years, and basically anything an association needs on its day-to-day legal needs are the services we provide, be it advice on governing documents, what they can and cannot do, what owners cannot do, or what they can do, collecting of assessments, negotiating with vendors, dealing with contract disputes, enforcing covenants, construction defect. We have board certified construction defect litigation attorney as well at our firm. So pretty much anything an association sees from a legal need on a day-to-day basis is what we do at K. Bender Rimbaum.
Well, I got to tell you, it's been a pleasure. This is my own personal opinion. You're a very large law firm, but I have watched you grow. You're in Tampa. You just opened up offices in Orlando. You're in Palm Beach. You're in Pompano, and it's just been a pleasure to watch your firm grow.
Thank you.
So here's how we do it here. We are going to spend the next 50 minutes answering your questions. We get a ton of questions, people writing in. We also will be answering your questions, people that are going to be writing on our chat line. And you can call in at 561-623-9429. Give us a call if you've got a question for attorney Robert K. Robert, let's start off in Boca. Kirk, he wants to know, can you give me some clarification on whether our condo docs always come first or the statutes trump docs?
Well, that's an interesting question that comes up quite frequently, and there tends to be a lot of confusion on what comes first. And it really depends on the issue that we're talking about for the most part. The statutes are applicable in many ways across the board, but there is an issue that has developed through the years that will depend on which will supersede, a current statute or a statute from years ago when the documents were first recorded in the public record, depending on how the documents are written. Some items, such as election of director procedures and things of that nature, are going to be applicable no matter when they were applied, being considered procedural in the law. And other issues might not apply. They'd look to the documents that are vested contractual rights, such as the right to vote or the right to lease your property. And so those types of issues, the statute may apply or the documents may apply. It's actually a fairly complicated issue that is a good idea to consult with the association attorney before trying to figure out which one is applicable. Many of the courts, we find, just look at the statutes and apply what the statutes say no matter when they were, but that's not necessarily the correct legal outcome under the law, but courts sometimes make mistakes. That's why there are appellate courts. So generally speaking, the statutes are the highest level of authority. Local ordinances come after that. Then the governing documents, your declaration is highest, your articles of incorporation is next, your bylaws is under that, and the rules and regulations fall below that.
Okay, let's go to Jen in Davie. If one person holds two seats, president and treasurer, do they get two votes?
Well, we have to keep in mind that the president and treasurer are officers and their function is not voting. Directors are the ones who vote, and there's usually a number of directors as set forth in the documents of the community, and each of those directors has one vote. The officers, the president, the vice president, the secretary, the treasurer, they have day-to-day corporate functions that they do in accordance with the bylaws, but they don't vote. So if somebody serves as president and treasurer, then they're serving those functions, the chief operating officer, the financial officer, but they're not voting on anything. So it's really one vote per director.
Okay. Again, if you would like to call into the show, we love taking phone calls. The number here is 561-623-9429. If you'd like to watch the TV version, go to www.w4cy.com. It'll say view the show. You can watch from right there. We're going to go to our next question. Is Ted in Delray Beach. He wants to know, is it true a board member can be held personally liable for not knowing all the new laws?
Well, no, it's not true that a board member would be held personally liable for not knowing all the new laws. Where the board member's personal liability can occur is if the board member intentionally or willfully disregards the existing laws or chooses to not become familiar with them in a way that would be willful in not attempting to comply with existing laws. And then, of course, there could be some personal responsibility if there's an improper financial gain being taken by the director, or if they're grossly negligent in their fiduciary obligation to the association, which is a very high standard of it's super negligence, as it were, and it takes a very egregious situation for that to occur. Merely not being aware of the laws, it's not something that most board members are intimately familiar with, which is kind of why you have people like myself providing services to the association, because there are many laws, and they can be intricate and involved, and expecting every board member to know them all would not be reasonable.
Okay, let's go to our phone lines. Let's go to Pete in Venice. Good evening, Pete.
Good evening. Thanks for taking my call.
Yes, sir.
Yes, I have a question.
You have a question?
Regarding
Okay.
annual elections for directors. It was my understanding that condominiums require that they have to have a secret ballot, and someone is suggesting that we could have the ballots emailed to a management company. Would that be acceptable?
Well, there are two ways for voting in condominium elections now. It's the mail-in ballot, and then there's electronic voting, which is a different set of circumstances and procedures. The more standard way is the mail-in voting, and where you deliver the ballots isn't going to change the secret nature of them, because procedurally in a condominium, an owner will mark their ballot, place that ballot into what's called an inner envelope, a blank envelope, and that envelope gets placed into an outer envelope, which has information for the association for registration purposes, the name of the unit owner, the unit number that's involved, and their signature. And that's what's collected. And none of these are to be opened until the meeting is to begin. And that's generally after all the ballots are registered and confirmed that they're from the appropriate individual within the condominium. Then they get opened by first removing the inner ballots from the outer ballots and setting aside the outer ballots, not throwing them away because they have to stay in the records, and then separating the inner envelopes, the ballots from the inner envelopes before you look at them. So you don't know whose envelopes you're looking at that point, and that maintains the secrecy of the ballot.
Okay, well, in this question, the question was that they're saying, someone is saying that we could have the voting owner take a photograph or a copy, a scan or whatever, and email the ballot itself to the management company, let's say.
Well, that would not be one of the two choices.
Secret ballot.
You can't vote by email. You have to have your inner and outer envelope presented to the association, or use the electronic voting procedure with an independent third-party company, and then it's an electronic vote. It's not an email vote. So what's being suggested to you would not be in compliance with the statutory procedure for voting in a condominium.
Good. Thank you for answering the question. Appreciate it.
All right, thanks for listening.
Thank you. Hey, we're going to go to our, we're going to go to our new comment line from Ace. It says, now that a post-pandemic, can Zoom meetings continue if the association provides a location to watch a live stream of the meeting for owners, and the board is not in the room of the live stream?
Well, that's a question that's still evolving in the law. There hasn't been anything either in the courts or otherwise that would indicate that Zoom meetings are not allowed. As long as unit owners have the opportunity to access the meeting and be heard and hear everything that's going on, that would be in conformity with the statute. It doesn't matter where the board members are. Having a place at the community where people can gather to do that is an added plus. Whether that would absolutely be necessary in a Zoom setting when nobody's physically there is something that, in my opinion, would not be necessary, but it is certainly a way to avoid any type of legal challenge that somebody might offer. And certainly that's something you might want to consider if it's a membership meeting for the unit owners as opposed to just a board meeting. That's an interesting question.
Yes. Hey, you know what? You have a lot of things going on
We do.
this
I've
month.
only seen one
Now,
on the scroll.
we're running it. Yes, we can see it on the scroll, but can you do it
I've
with
only
your
seen one
eyes?
of them. I've only seen one of them, and we have quite a few others. We have classes that we're doing. The first one being next Wednesday, February 8th, Association Leadership, Election, and Annual Meeting, Best Practices and Pitfalls. It's a Zoom presentation hosted by the Castle Group with a panel that includes Michael Bender and Jeff Rembaum. That will be at 12 noon to 1 p.m. next Wednesday. And then on Friday, February 10th, a rare Friday, translating SB-2A, Senate Bill 2A, how the Florida insurance reforms affects your association. That's at 2 o'clock to 3 o'clock Zoom, and that will be with Sean Brown, and it's hosted by Kay Bender-Rembaum. On Thursday, February 16th, Condo and HOA Board Member Certification. It's an evening presentation from 6 to 8 p.m. It's combined for Homeowner Association and Condo Board members. It's hosted by Associa, and Emily Gannon from the firm will be providing the instruction for that Thursday, February 16th. And then on Tuesday, February 21st, we're also going to do another certification meeting for both condominium and HOA from 1 o'clock to 3 p.m. That will be hosted by Rio Manage, and Lisa McGill from our Pompano office will be providing that presentation from 1 o'clock to 3 o'clock. Those two board certification courses do not have continuing education for managers, so be aware of that. There are upcoming expos as well. The Broward County Expo is going to be on February 7th at the Signature Grand. And we've got two courses we're presenting there at 12:45 to 1:45 p.m. Navigating the Federal Fair Housing Act, Assistance, Animal, or Pet. And that will be Andrew Black. And there's one CEU for that. At 2:30 to 4:30 is the Legal Update 2023, which is the laws from 2022. And Michael Bender will be presenting that. Now, on February 22nd, at the Palm Beach County Expo at the Palm Beach County Convention Center from 9 o'clock to 10 o'clock, we'll have the Navigating the Fair Housing, Assistance, Animal, or Pet. Danielle Brennan from our Palm Beach Gardens office will be presenting. And then at 2:30 to 4:30, the Legal Update for 2023, we'll have Jeff Rembaum presenting. And then on the 28th of February, there's a Tampa Bay County Expo at the Tampa Convention Center from 9:30 to 10:30, Covenant Enforcement for Homeowners and Condominium Association. Sean Brown will be teaching that. And then at 2:30 to 4:30, Sean Brown will also be teaching the Legal Update 2023. So February has a lot of things going on. You find all these things by going to our website, kbrlegal.com, clicking on the event calendar, and you can register for any of those items by doing that. Or you can send an email to info@kbrlegal.com.
Very good. Wow, that is a busy month this month.
It is.
We're going to go to a break. Robert, give everybody the number at the office.
You can reach us at 800-974-0680. Write us at info@kbrlegal.com, or just go to kbrlegal.com.
We're going to go to our first break. Again, if you've got a question for Attorney Kay, you can call us also at 561-623-9429. We'll be right back.
Kay Bender-Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several Kay Bender-Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Benda Rembam is also a well-known provider of free legal education for managers and board members. Contact K. Benda Rembam today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
Yes, and we're back. This is the Ask the Expert show. We're with you every Thursday from 5 p.m. to 5:50. The first Thursday of the month is our association law. K. Benda Rembam. We're going to go to our caller on the phone, Brian, in Palm Beach Harbor Club. Welcome to the show.
Are you there, Brian?
Brian?
No,
Turn your radio down.
Yeah, thank you. Can you hear me on this line?
Yes.
We can hear you fine now. Turn your radio down in the background now.
Can you hear me?
Yes.
What do you need me to do?
Ask your question.
The question, gentlemen, is that we have a contract that ended with a washing machine company. It's a 10-year contract. We ended it with a certified letter according to the contract. They won't pick up the machines. Is there anything that we can do?
Well, that's something that may require formal legal action to protect your interests, because being that it's their property, if you do anything to it, that could subject you to a claim of some kind of damages to the machinery or something else. So if the association has counsel, your counsel should be involved in notifying them that they have to get the machines out by a specified date. They'll be considered abandoned, and then they'll be moved into a storage situation, which they'll be responsible for the costs, and attempt to get them to cooperate in that fashion. If they continue to fail to do that, your attorney will need to address with you the other options of whether you need to file formal legal action to compel that, or if it's a possibility of simply having them removed and destroyed.
Okay, so the counsel is needed as the next step.
If they're ignoring you, yes.
Okay,
Brian from the Palm Beach Harbor Club on the line. Thanks.
Thank you very much.
All right, Brian. Thank you for listening.
Thank you. Bye-bye.
That was interesting. Never heard that before. Okay, let's go back to, if you've got a question that you'd like asked about association law, you can give us a call here at 561-623-9429. Let's go to our next question. Monica in Boca Raton. She said, my question is in regards to our annual elections. What disqualifies a candidate? When is disqualification determined?
Did Monica say if she's a condo?
She did not.
Okay. Well, the condominiums are a little different than HOAs on this subject, and this is one that tends to be more a condominium type issue. There's limited situations that condominium associations have that can disqualify an individual from being an individual unit owner from putting their name into candidacy. And that would be if they are delinquent in assessments to the association, if they have a felony record that hasn't been lifted for more than 5 years, or if the division has suspended them, which is an unusual situation. And the key times for that are on the last day of submitting a notice of intent to run. And quite often, people could have open balances on their assessment account, not realize it on that date, and become disqualified. So if you're looking to be a candidate for the board in a condominium, you want to make sure your account is up to date sooner than that last deadline date. And then upon election, there's a different delinquency standard, but if they're delinquent at that point on the election, then they'd be basically off the board at that point, and again, disqualified. And the other issues also disqualify as well, with the felony conviction and suspension from the division. HOAs could have provisions in the documents that might disqualify a homeowner from serving, and Chapter 617 does recognize the Not-for-Profit Corporate Act. The bylaws could have certain things. The condominiums are a little different in that regard, and the division takes the position that any unit owner that does not find themselves disqualified, as the statute provides, are entitled to put their name into candidacy. HOAs might have situations that have additional limitations, such as residency or another situation. The other point to keep in mind is that there is a limitation on the number of owners from a unit that can serve or run for or serve on the board at the same time. They can both run, but a husband and wife generally in condos are precluded from serving on the same board unless they own multiple units or there aren't sufficient candidates to meet all of the seats that are available.
Okay. This is, and we just got another, I don't know if it's the same one or not. We got another washing machine company that they had canceled their contract. Now, they said they sent a certified letter to the company to come pick up their washing machine. I don't know if it's the same one or not, but we'll move on. Here's Jack in Boca Raton. He says, our condo exterior is being done. They are changing the color so it's a common element, but a vote was never taken. What can we do?
Well, the documents have to be reviewed to determine whether it's a material alteration that requires a vote of the owners. The statute provides that there can be no material alteration or substantial improvement unless in accordance with the governing documents. And if the documents are silent, then upon a 75% vote of the owners. The division has interpreted a change of exterior color to be a material alteration. And because of that, it's a suggestion that any community whose documents require owner approval on color change or material alterations do get that. But sometimes the documents don't require every material alteration to get a vote. Sometimes if the cost is tied to a certain dollar figure or percentage of the overall budget, that might allow certain things to go through. For instance, a change of color doesn't cost any more than a color changing from. So if there's a dollar benchmark before it kicks in, a change of color would not require a vote of the owners under those circumstances. So really will depend on the documents as to whether or not an owner vote is going to be required in that situation.
Okay. Well, you know what? Ask an attorney that you do,
Yes.
and that people come in with maybe one question, and then after they hear people asking other questions, they come up with 4 or 5 more questions. Well, our comment line is getting so many questions. Here's a follow-up question from Ace. And Ace says, can a condo regulate what an owner charges for rent of a unit they own with said owner not delinquent with monthly and special assessments? Is it a document thing?
In my years, I've never seen a community document that limits the dollar that an owner can charge for rent. It's usually market driven, but it's legally okay if it's in the declaration of condominium that sets a rental limit. I can't imagine owners voting to agree to that if it would be an amendment, because it's not going to be in original documents, but it would need to be in the documents in order for it to be enforceable.
Okay.
Not by rule.
Let's go to Marza in Bradenton. Hello, Marza. Marza, are you there? Let's put Marza back on hold if we can, and we'll come back to her. Okay, let's go to Bill in Lake Clark Shores. Bill wants to know if you have, from time to time, Kaufman language written throughout parts of your condo docs. In order for it to be valid, do we need to amend our docs with the statute language?
Well, it sounds like. Uh-oh. I think I messed up.
Okay.
Can you hear me?
I can hear you fine.
Okay. If it's already in the documents, then there would be no need for an amendment. Oh, I see what I did wrong. Okay. I opened another window by mistake.
Oh, okay.
Sorry about that. I shouldn't be pushing
That's
buttons.
Okay.
If the documents provide for that, then it's already there. And so an amendment would not be necessary. Now, one thing that the questioner might be thinking is, let's say it's specific to a particular provision that has the Kaufman language, and they want to have it applied to the entire declaration. In that situation, it's very possible an amendment would be needed to get the blanket coverage of the Kaufman language to the entire declaration. So we'd have to see the document and be able to see exactly what they're trying to accomplish to give the complete answer on that.
Okay. Let's try Marza again in Bradenton. Marza, are you there? I guess Marza has gone away. Okay, let's go back to, if you do have a question, you can also call us here at 561-623-9429, or you can go right on the screen and ask your question on our chat line. We're going to go to Julie in Boca Raton. Can a condominium board member be removed for not following Florida 718 statute?
Only by the division of condominium, and I've not ever seen that happen. The only way owners can remove a board member is by recall or at the next election. So recall can be accomplished by a written agreement, which if they have forms available at the Division of Condominium website and under the Department of Business and Professional Regulation. And it's a fairly simple form to use, self-explanatory, where you put the names of the directors that you're trying to recall, and the owners vote whether they want to recall or retain them. If they're recalling more than a majority or more of the board, then they could put in replacement directors. Otherwise, the remaining board members would appoint to fill the vacancy.
Okay. We're going to go to Kyle in Palm Beach. We are a condo. I'm trying to train our viewers and listeners to tell us
Definitely
if you're a condo
to
in HOA. And Kyle wants to know, is adding pickleball court markings to our tennis courts considered a material alteration? It would serve as both tennis and pickleball?
Well, along the same lines as color of paint, we expect the division would consider the painting of additional lines on the surface of the tennis court to create the pickleball markings to be sufficient to be a material alteration. So then the question would be whether or not the documents require an owner vote under those circumstances. So you'd have to look at them to make that determination. It seems silly because it's still a tennis court and it still has tennis court lines. And I think that an association could consider that not to be a material alteration if they're willing to accept the risk that somebody complains to the division and the division fines against them, which could subject them to a fine or some kind of a requirement and a record of violation. But it would take someone to complain for that to actually happen. It's not the clearest of issues on material alteration, but it is one that these days comes up fairly regularly because pickleball is becoming more popular than tennis.
Okay. Let's go to our phone line. Let's go to Susan from Tampa. Hi, Susan.
Hello. My question is, if 3 of 7 condo board members appoint themselves to secretly interview insurance agents and then ask the board to vote to select the insurance agent they recommend, even though other board members asked to be included in all of these interviews, what can be done about that? Anything?
Well, 3 of 7 board members can't appoint themselves to do anything. So what they've done isn't a formal action of the association. If the other 4 board members want to consider what they're recommending, they can do that. If they choose, they don't have to. So it's up to the 4 members of the board as to whether or not they want to let that happen.
So we have one additional board member who's rather silent and uninterested, and they'll probably persuade that person to join these 3 that did the interviews and then approve a change in the insurance agent.
That majority rules.
But they appointed themselves and excluded the rest of the board. That just doesn't seem right.
You're right. It is not right. And the owners have the option, if there are sufficient number of them and of the mind, to remove them as directors and put in new directors more of their taste and desires and of their mindset, including the one who is wishy-washy. Right. Assuming you have enough other people willing to serve on the board, which is not necessarily a simple thing.
Right. We have a number of people interested, more than the 7. So there's definite interest.
Okay. Well, also with recall, you have to be sure of your timing, because if you're within 60 days of the annual election, either before or after, that you're not supposed to be doing recalls during that time frame.
Exactly. We understand that part. Thank you very much for your advice.
You're welcome. Thanks for listening.
Thank you for your call. Wow, busy. We're going to go to break, our last break. Give everybody your phone number and your website. And I'm going to tell you, people, this is the greatest website. There is so much educational information on there. You can learn so much. So give everybody the phone number and your website address.
Now, the phone number for all of our offices, 800-974-0680. KBRlegal.com. If you click on resources, you can choose articles under Rambam's Roundup or Legal Morsels. There's many articles of topical interest through the years that there are available for anybody to look at. We don't limit that to just clients. And you can also write to us at info@kbrlegal.com.
Great. We're going to go to break, our last break. We come back. We've got more of your questions. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
This is the Ask the Expert show. We've got about 10 minutes left in the show. If you'd like to call us, we have time.
I think all of our listeners want to know. Where's Sophia?
Oh, go ahead.
Where's Sophia?
Oh, she was put in the hospital with blood clots.
No.
Yeah.
She's okay.
She is getting better. Thank you. You know, blood clots always scare me because you hear all these things.
Oh,
but
sure.
She's in the hospital. She's at the Boca Hospital. You know that. So, I wanted to get to the phone number. It's 561-623-9429. If you'd like to watch our show or go to our chat line, go to www.w4cy.com and you can ask a question online. You can make a comment. We just got all kind of new bells and whistles for the show. We're going to go to our text line and let me see. We're going to go to Parker in Deerfield. Did the request to inspect condo documents change from 7/18 to 7/20?
Well, each of them have their own provisions for how to request. They both require written requests. The HOAs do indicate certified mail as what starts the clock running for the time frame to provide the access. In a condominium association, the division has allowed boards to adopt rules that require certified mail requests, but the statute itself doesn't specifically say that. Generally, otherwise, the two statutes are substantially similar.
Okay. Well, you know, this is, I think, in 6-7 years' time, I think this is the first time that we have had a elevator question. They want to know, this is Stephen in West Palm Beach, can elevator companies legally increase fuel surcharge fees over 100%? My elevator company went from $125 to $250 from 2/21 to 2022. Contractor failed to provide supporting documents.
Well, I'm not sure what the fuel surcharge the writer is asking about, but there is no current statutory restrictions one way or the other on fuel surcharges that various entities can be charging. If you have a provider of services that is charging a fuel surcharge that you consider excessive, then the advice would be to consider finding a different provider if you can. Whether or not that would be a breach of their contract with the association would depend on the contract documents to see if that's something they can do. That's an area that, since the fuel costs have gone up substantially, and periodically we see various vendors added, but it's never really as significant as that. It's usually, a relatively nominal amount.
I think that's the first elevator question we've ever had. Let's go to Brock in Hollywood. There was a special assessment approved by our board members within 14 days to pay $6,000 per unit for 16 buildings and pool house to be re-roofed. My unit is not on the list. Is this legal to have to pay?
So, understanding the question, they're saying that there's a condominium with multiple buildings, then some of the buildings are getting roofs, but not all of them. And
yes,
the writer building is not. Do they have to pay? And the short answer is yes. If your documents, if it's one condominium and all the buildings are part of one condominium, or the building he's in is part of a condominium that's getting roofs done to any part of it, then he's responsible for his share of the assessment for that particular condominium. So there is no limit, short end, as to when an association can make the assessment due. They can make it due tomorrow if they want. So 14 days is not something, while it's fast and it's a significant sum, it's not something that the law does not allow. So that you would have to make sure that he's part of the same condominium that's having the roofs done and that the assessment is for. And if so, then like any owner, he's responsible for his proportionate share.
Okay, we got a few minutes left. I'm going to go to Jill N. Davey. Do the new mandatory reserves apply to every condo or only for the 3 stories or higher?
Well, they're not in place yet, but there isn't clarity in the law as to whether or not these reserve requirements do apply to all condominiums, but the division has indicated their position that it applies to all condominiums, not just the 3 stories or more that are subject to the additional inspection requirements and reporting requirements that was adopted last year. So the conservative approach for the association to take is to implement the mandatory, but not all of the reserve items are mandatory, only the structural ones. Other ones that aren't specifically listed in the statute can still be reduced or waived.
Okay. Well, we've come to the end of another show. We have so many moving parts now on our show, but we got through it though. Give everybody your phone number and your website address.
You can reach us at 800-974-0680. The website is kbrlegal.com. You can go into that website. There's a box to fill out with contact information, and someone will respond to that. You can write to us at info@kbrlegal.com, and someone will respond to that inquiry as well. I will say, though, you're not, the time to ask questions is here. If you have a question and you want our assistance, you're going to need to engage the services as a formal lawyer-client relationship. So that's something that I want to make clear and that everybody understands. But we're happy to answer as many questions as you can pose to this show whenever we're on.
And K. Bender Rimbaum will be back the last Thursday of this month at 5 o'clock again. So please stay tuned. And we'll be back again next week with more Ask the Experts. Thank you, Robert.
See you
we'll
next
see
month.
you again next month.
Have a good one.
And we'll see you all next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.